Hello, everyone. My name is AJ Weisler, and I'm a partner in Husch Blackwell's Labor and Employment Group, and I'm excited to be your host for today's virtual webinar. As probably was the case for most of you, I went away from the office. We've been away for a while, a little over a year, and we came back, and our decor was replaced with sort of futuristic walls with lit up holes. And I'm excited to be coming to you from an office, and we're also going to be using a studio for our presentations, also in the St. Louis Husch Blackwell office, and I'll be sending it over there shortly for our first presentation. Before that, I wanted to welcome you all and give a little bit of housekeeping to help you understand how best to take advantage of today's presentations. So first of all, this is our second virtual seminar. We did one last year as well. We're going to be focusing primarily on Missouri, Illinois, and other regional law, and we'll also talk about federal law, of course. And we have guests attending us from Kansas, Missouri, Illinois, and possibly some other states as well. So at the bottom of your audience console, you'll notice that there are a number of buttons and applications available to you. If you have any questions during the webcast, you can submit those via the question box. And we have a team of attorneys who will do their best to answer any questions that we receive during the webinar. But to the extent that there are any questions we're not able to get to, or those that maybe require a more full answer, we will complete those and respond to you by email. A PDF of the presentation that you're going to be looking at, as well as other resources, is also available in the resources folder at the bottom of your screen. And as always, this program has been approved for HR and legal education hours. And to report those hours, you're going to want to click on the CEU icon at the bottom of the screen, and a certificate of attendance along with the link for the recording of this presentation will be sent to you tomorrow. And of course, you're welcome to share and rewatch, and you're going to want to do both as often as you can. Toward the end of the program, be sure to complete our short survey. We always appreciate those of you who do so. It provides us with a lot of useful information that helps us make sure as we design our future programs that we are giving you content that is as useful as possible. And that is it for our housekeeping items. So we'll get started with our program. Today we have three substantive presentations. The first two are each 30 minutes in length, and the last one is an hour. The last one qualifies for ethics credits, and in Missouri, it qualifies for the Elimination of Bias credit. There will be short breaks in between each of the substantive presentations where the studio will throw it back to me, and we'll spend some time talking about some other things there. But certainly if you need a break or if you need to step away for a while, that'd be a great time to do so. The three presentations that we have will be first, the legal update presented by Joe Glinius, by Anthony Grice and Kate Copen. After the legal update, we'll have a presentation on COVID-19 vaccines and your workforce, presented by Brittany Falkowski, Kayla Lovelace, Bob Tomaso. And then last up, the Elimination of Bias and Ethics presentation will be Carrie Claiborne, Sunny Nolan, and a guest speaker, Professor Kimberly Norwood, discussing best practices for developing cultural competency in your workplace. So without further ado, we'll send you over to Kate Copen in the studio for our first presentation. Thanks.
Good morning. I'm not Kate Copen, but I'm standing right next to her, and I'm standing between two ferns or two bushes here at Husch Blackwell. But we're excited to all be here together. Obviously, it's been some time since we've been in that position, and we're excited to be able to be seen by all of you. Although we're looking forward to the day when we get to get back into a big room and spread as many germs to each other as we possibly can. As AJ mentioned, we're going to be providing a legal update this morning. Lots going on, obviously, over the course of the last 6 months, and we're going to give you just hit the high points of some of the things that will matter most to employers. We're going to start with our new administration. The Department of Labor has been busy, not a surprise when you see a change from one administration to the next. This is very typical, particularly when you're talking about changing parties, so the DOL has been active. First thing, joint employer rule. Under the Trump administration, the Department of Labor had proposed a new rule that sufficiently narrowed the scope of who could be a joint employer when two businesses are sort of working together and using the same individual or individuals to perform services. Under the Trump administration rule, there were only 4 factors that were in play, and it was significantly focused on the amount of control that an organization would exert, and that's key, exert over that individual to determine whether or not the organization was in fact a joint employer over that individual. So Imagine you're a company using staffing agencies for temporary assistance. The question becomes, do you employ that person? And under the Trump rule, only if you actually exerted control over that employee would you be determined to be the joint employer. Just merely having the authority, which a lot of these contracts would provide, wouldn't be enough in and of itself. When the administration changed over to President Biden, the DOL proposed to rescind that rule. It's not effective yet, but they proposed to rescind it back in March. And we are expecting that we are going to see a much broader rule defining who is a joint employer under the Department of Labor, with the purpose of capturing more organizations as the quote unquote employer of each individual. And instead of being focused only on control and actually exercising that control, having the authority to exert control would be enough. Plus, it wouldn't just be that, it would be maintaining employment records, how long the relationship goes on. There are going to be many more organizations most likely captured under this expansive definition. We don't know what it will be quite yet. The PRO Act that recently passed the House of Representatives includes in it this broader expansion, so we expect that to be the case. The upshot for now is let's wait and see. Let's see what the administration does, what the DOL recommends, and plan for, in your agreements with your other organizations, to account for this. Who is actually the employer? Perhaps have indemnification provisions. You're going to want to use counsel to make sure that gets right, but that'll be an important first step. So that's the joint employer rule. Similar to that is the independent contractor rule. Again, the Department of Labor historically has offered an opinion, a position on when an individual is an employee or an independent contractor. Why does this matter? Again, because we want to know who is the employer, who is liable to be sued by the employee. Historically, the Trump administration, again, had a much narrowed rule of independent contractor. In fact, focused on two factors compared to the others. And again, very heavily focused on who exerts the actual control. That has actually been withdrawn now. That rule no longer exists. The Department of Labor has not proposed a new rule, but again, the PRO Act that I just mentioned that has passed the House includes a definition of who is an employee versus independent contractor, and it relies heavily on something called the ABC test. Now, the ABC test is a test that's almost impossible for an organization to apply to an individual who works for them and avoid a finding of an employment relationship as opposed to an independent contractor relationship. All three factors have to be met. I won't go through all three of them, but the key is, the second one is, if the individual is performing a service that is an integral service of the organization, so if your organization makes tires and this person is brought in as temporary assistance to make tires, that person in all certainty is going to be found to be an employee. So even though it's only temporary, even though some other organization might issue their paychecks, hold their personnel file, all that stuff, in all likelihood, they're going to be an employee. That hasn't been put in place yet, but that's what we're expecting. It does exist in places like California, Nebraska, Massachusetts, but in terms of the federal rule, it's not there quite yet. But this does bring up an important point, which is to say that even though these department actions are important, they are not the law. Courts define the law. And this excerpt that you see here is from a case that actually our law firm handled, where the court basically said, where the DOL keeps doing this, where they keep switching back and forth on important positions, and based almost entirely because of the results of an election, we courts are not going to defer to what the agency says anymore. So let's pay attention to the DOL, let's see what they do, but the more they go back and forth, you have to know that the courts may or may not follow that. And given the back and forth we've seen so far, that the DOL might be heading in that direction. That's from the federal perspective. One note on some state case law that's, again, touching on the independent contractor versus employee question. This is a case out of Kansas City, the Western District of Missouri Court of Appeals. They had a case where a bunch of individuals performing pet sitting services, where they might come take your dog out for 20 minutes or take them on a walk and then go to someone else's dog. The court found in that case that the organization actually employed these people as opposed to treating them as independent contractors. The organization argued, we're like Uber, we just put people together, customers and service providers. The court said no, and they applied an IRS 20-factor test. in terms of the right to control these people's schedules and other terms and conditions of employment and determined they were employees. So again, the upshot here is we are seeing a situation where the courts in Missouri are finding an employment relationship where the organization otherwise held for an independent contractor relationship. Now I will turn it over to Kate Copen.
Thanks, Joe. So I'm going to talk a little bit about the new EEOC guidance on religious discrimination and accommodations of religion in the workplace. So earlier this year, the EEOC issued new guidance on these topics. It does not have the force of law, but it's a good practical guide for employers. It gives a lot of scenarios and also provides some insight onto how the EEOC will be investigating and enforcing charges of religious discrimination. So this guidance clarifies that religion is still defined very broadly. It's really any sincerely held religious belief or observance or practice, regardless of whether it's mainstream, and even regardless of whether the individual believes in a god or gods, as long as that sincerely held belief holds the place in that person's life where in a more traditional religion a god would. So employers cannot discriminate against people on the basis of their sincerely held religious beliefs or practices or observances. In addition, reasonable accommodations have to be made for religious practices or beliefs that may conflict with job duties. Even if the employer doesn't think that it would necessarily create a conflict, if the employee is sincerely telling you that it does, you know, the employer has to consider that and consider what would be a reasonable accommodation. Now, unlike the disability context, where there's a pretty high burden to show an undue hardship, in the religious context, an undue hardship means something that's more than a de minimis cost. So it's a little bit of a lower burden. And this new guidance does encourage employees and employers to have that interactive dialogue in determining what is a reasonable accommodation. So it is okay as an employer to ask the employee to explain their sincerely held religious belief or practice and how the employee believes that it interferes with their ability to do their job duties. Since we're on the EEOC, they have resumed collection of EEO1, Component 1 data. You can see the timeline here. They just announced this in March. So from April to July, it's a little bit of a longer period to submit that data. I think it's 12 weeks as opposed to 10. If you are responsible for submitting EEO3, 4, or 5 data, there's estimates, opening collection dates, filing deadlines are to be determined, but you can go on the EEOC's website to get those exact dates. But as you probably know, if you're an employer with 100 or more employees or a federal contractor with 50 or more employees and a contract of $50,000 or more, a federal contract, then you are required to file this EEO1 Component 1 data. And that's information about gender, race, and ethnicity broken down by category, job categories in the workforce. So EEO 3, 4, and 5 deal with, unions, schools, government employees, but just wanted to make you all aware that they have resumed that collection because it was put on hold in 2019 and 2020 due to COVID.
Thanks, Kate. So there are a few executive orders that I want to talk to you guys about. The first one relates to diversity and inclusion, and this is important for any employer who's a federal contractor. To give you a little history, back in September of 2020, President Trump signed an executive order that stated a couple of different things. Number one, employers could not provide any postings or documents related to diversity and inclusion training in the workplace. It also required employers who were federal contractors to put in any contracts or agreements that they would not do any diversity or inclusion training or provide such documents. The last thing it did was it required the federal agencies to do a review of any grants and or existing contracts related to diversity and inclusion training. Later on, a couple months later, the court started to roll that back. The Northern District of California federal court issued a preliminary injunction in the Santa Cruz case that basically said, employers can continue to do diversity and inclusion training in the workforce and don't have to apply with President Trump's executive order. Since the Biden administration has come into office, they have gone a step further. In January of this year, President Biden issued Executive Order 13985, which is titled Advancing Racial Equality and Support for Undeserved Communities Through the Federal Government. What this executive order specifically did was roll back the executive order signed by President Trump and supported the preliminary injunction in Santa Cruz. And so for you, that as a federal employer who's a federal contractor, that means you are able to do diversity and inclusion training now without any issues or first issuing documents to the Office of Personnel Management. You can post those documents in the workplace. And also, there's not going to be any review by any federal agencies as it relates to those documents. So under President Trump, you had to issue any potential training documents to the Office of Personnel Management before doing any diversity or inclusion training. You no longer have to do that pursuant to President Biden's new executive order in January 20. On the same day, President Biden also signed Executive Order 13988, preventing and combating discrimination on the basis of gender identity and sexual orientation. And so this executive order did one simple thing. It basically reinforced the EEOC's guidance and guidelines on Title VII that states that gender identity and sexual orientation is covered as a protected characteristic under sex and gender under Title VII. And so this just reinforces that that idea that employees are now protected as a protected characteristic under their gender identity and sexual orientation. So I'll pass it to Joe for EEOC guidance update.
Yeah, so we couldn't get through the case law update without touching a little bit on COVID. Of course, throughout the last year, we saw a lot of agency action, a lot of rulemaking happening very quick in real time. And one of the issues that came up along the way was in January, the EEOC released some guidance regarding wellness programs that employers offer. And the background here that's relevant for us is obviously a lot of employers seeing the vaccines on the horizon were considering, well, can we offer incentives for our employees to get vaccinated? The EEOC spoke up talking about wellness programs and said, you can offer incentives provided they are de minimis. And by de minimis, we mean really de minimis, like a water bottle, a really small gift card. So it was challenging for a lot of employers to say, well, how do we do this? Is this essentially telling us we shouldn't be giving incentives to get vaccinated? Quickly, a lot of businesses got together. They petitioned the EEOC to clarify its guidance or withdraw the rule. That happened on February 12th, right after the Biden administration took over. And on May 28th, so very recently, the EEOC released actual technical assistance guidance on COVID-19 vaccination, making clear that employers can provide incentives for their employees to get vaccinated. They can't be so substantial as to be coercive, like, you're not going to get paid next month if you don't get this done, but they can be significant, a few $100s, something important, and a lot of employers have responded. That limitation, by the way, about not being substantial doesn't apply to people who get vaccinated by third parties. These are vaccinations conducted by the employer. Next one, this is about expense reimbursement. Again, a big issue coming out of COVID. A lot of people working from home, using their home internet connections, their cell phones, et cetera. And there are a couple of states, or more than that really, have issued guidance regarding what employers have to do to reimburse their employees. We're talking about it because Illinois recently passed this law. And under Illinois, there's a lot of uncertainty as to what the law will mean. Well, California has had theirs for quite some time. And in California, there has been cases, a lot of class action cases, where they're petitioning courts to get reimbursement from their employers. And the cell phone is the case that you see on the screen. The big distinction between Illinois and California is under Illinois, if you are an employer that actually maintains a policy that sets expectations and a process to get reimbursed and has reasonable, not de minimis, but reasonable limitations on how much that reimbursement will be, then you're going to be fine. And even though you might reimburse an employee $20 for their cell phone reimbursement, if they wind up incurring $80 worth of charges, you aren't going to be on the hook. So having that policy is very important for employers in Illinois. By the way, okay.
So this is an OSHA update here on the new enforcement plan that OSHA is implementing due to COVID-19. And so this is a national enforcement program that OSHA is implementing related to COVID-19, specifically for employers who are already at high risk, where employees' jobs have an increased risk of getting COVID-19, or they're in critical industries. And so under this new program, the OSHA is going to allocate more resources, new resources to inspections and holding employers accountable under the OSHA for maintaining the safety and welfare of their employees in the workplace. Approximately 5% of additional resources will be added to the NEP so that they can do these inspections and enforcement. The OSHA guidelines on this suggest that employers should adopt the NEP and post information about the new enforcement program for its employees to see. And that 5% increase is going to be per region. And so Missouri's in Region 7 and Illinois is in Region 5. And so each of those regions is going to receive a separate increase of 5% in their budget for these inspections. The inspections are going to start immediately. And so don't be surprised if you get a notice from OSHA or an OSHA inspector shows up in the workplace to do an inspection on the NEP to go over your COVID guidelines and processes and procedures and how you're maintaining the safety in workplace for your employees. The last thing the NEP does is it contains additional anti-retaliation provisions for employees who either express concerns to OSHA about safety or workplace issues or express those concerns to their employer. The next update is on the PRO Act, and the PRO Act it's employer-friendly legislation, pro-union legislation that pretty much does an overhaul of the union organizing efforts. It makes it easier for employees to attempt to unionize. There's a list of 6 factors here that are changed by this, and the major one I wanted to highlight here is that it revises the definitions of employee, supervisor, and employer to broaden the scope of the covered individuals. And so ultimately, the PRO Act is going to make it a little bit easier for employees to unionize in the workplace. The legislation was passed in the House and it was sent to the Senate. And the latest action that we have is from March 11, 2021. It was referred to the Senate Committee on Health. And so this has not actually been passed into law yet. It's still in committee. At this time, given the makeup of the Congress, it doesn't appear that it's likely to pass in the Senate, but we wanted to make you aware of it in the event that it does before the next opportunity that we have to get in front of you.
All right, we got an Illinois update. So earlier this year, the Illinois Human Rights Act and Illinois Equal Pay Act were updated or amended in 3 main ways. So first, employers who are required to report EEO1 data, which we were just talking about a few minutes ago, now have to report similar data on gender, race, and ethnicity to the Illinois Secretary of State. Also, in addition to reporting that data, they need to, if you have 100 or more employees, you need to obtain an equal pay registration certificate from the Illinois Department of Labor. And to do that, you report that same gender, ethnicity, and race information along with pay information so that the state can make sure that pay practices are equitable. And then the third way that this bill impacted these laws is it amended the Illinois Human Rights Act so that criminal history is now a protected category under that act. So employers cannot discriminate against people based on their criminal records. Now, of course, there are exceptions, as with anything, and very similar to the EEOC guidance that says, you know, if you're going to make an adverse employment action based on someone's criminal history, you need to consider a bunch of different factors, such as the nature of the conviction, the relationship to the job in question, how long ago was the conviction, the number of convictions, the sentencing, the age of the individual at the time of the conviction. So all those same factors that you might already be familiar with are now mandated by Illinois law. In addition, if you're familiar with the Fair Credit Reporting Act, if you're getting your criminal record checks from a consumer reporting agency, well, now under Illinois law, there's similar requirements. Actually, even if you're getting your criminal history checks directly from the state. So in other words, if an employer is going to make an adverse employment decision based on someone's criminal history, they first need to provide a pre-adverse action notice. So they need to give the individual a copy of that record and give them at least 5 business days to present additional information to dispute it. And then the employer has to consider that information. If they still want to make the adverse decision, then they provide a final adverse action notice, which gives them information about how to dispute it even further. And it goes a little bit farther than the Fair Credit Reporting Act in that Illinois employers now will have to provide a little bit of the justification for why they made the decision that they did. And then the last thing I very briefly wanted to touch on is the St. Louis City Ban the Box Ordinance. So if you are an employer in the city, not the county, but the city of St. Louis with at least 10 employees, then as of January 1st of this year, you are bound by this new ordinance, which, similar to the factors we were just talking about, says, if you're going to make an adverse employment decision based on someone's criminal history, you need to consider, again, relationships to the job in question, how long ago was it, the age of the applicant, all those things. In addition, you can't have a blanket policy that you can't put it in job advertisements or in employment applications, some sort of blanket policy saying we won't hire anyone with any criminal record. So you can't do that. And then the third thing is you have to wait until someone is far enough along in the the application process before asking about or getting criminal record information from publicly available sources. Now, again, there are exceptions if by law, by state or federal or local law, you're prohibited from hiring people with certain criminal records. But for the most part, those prohibitions apply. And non-compliance with the ordinance, it depends on how many times you violate the ordinance and the severity, but it could jeopardize your ability to continue to do business in the city of St. Louis. Pass this back to Anthony.
So now to the fun part of the presentation. I get to talk to you about the weed. 2 updates for you on cannabis in Illinois and Missouri. If you've been in Illinois recently, you've probably seen or at least smelled the fact that recreational marijuana was approved and made legal in January of 2021. And so 2 updates on that. There are 2 bills, one's in the House, one's in the Illinois Senate. The current bill in the House would extend protections for individuals who have medical marijuana cards and also recreational users as well. It would expunge any existing criminal records for possession of marijuana. It would not extend to the growth or sale of marijuana, but it would expunge any possession offenses or convictions that were from the past. It also decriminalized possession and delivery, and there would be no amount restrictions in Illinois. And so I don't know why someone would need to have pounds of marijuana on their person, but if this passes, they would be allowed to possess and have on their person or in their home as much of marijuana that they want to have. The second one is in the Senate. It's the Employee Background Fairness Act. It would prohibit employers from disqualifying an employee or a job applicant who has a conviction record with some exceptions. And those exceptions track the House bill for the manufacture or sale or cultivation of marijuana, but anyone with a possession charge that would be expunged from their record. Here on the Missouri side, as you may be aware, medical marijuana was passed in Missouri, and there's currently continuing on the trend with several other states. Missouri also has a bill in the House, I believe, to legalize recreational marijuana, and it would do a lot of the same things that the Illinois bill wants to do in terms of expunging records, releasing prisoners who are in jail or prison for marijuana-related offenses, and also there would be caps on the number of distributor licenses in the state of Missouri. Currently, there is a cap on the number of licenses the state of Missouri can distribute to retailers of cannabis. That it would eliminate that. The second thing it would do is it would clarify the Second Amendment protection for Missouri citizens. In a lot of states around the country, particularly out west, if an individual gets a medical marijuana card, they essentially give up their rights under the state to own a firearm. Missouri's silent on that right now, but this act would clarify the fact that individuals who do get a Missouri marijuana card, they are not giving up their Second Amendment right. And so they would be able to own firearms and carry firearms, open carry and concealed, just as any other citizen would in the state of Missouri. The last update I have for you is on the Casey Crown Act. It's related to hair, which, of course, naturally, I'm the person to talk about that. So in October of 2020, in Kansas City, they passed the Crown Act, creating a respectful and open world for natural hair. This basically provides protection for individuals who choose to wear their hair naturally. We've seen this trending locally in the region and across the country, where employees are complaining about being discriminated against, not because of their race or not necessarily because of their national origin or anything like that, but because they wear a natural hairstyle that is related to their race or natural origin. And so this Kansas City, Missouri Act, it provides specific protections for those individuals who want to wear natural hairstyles and hair textures associated with their race. There's similar legislation, not there yet, but there's similar legislation trending in the state of Kansas, the state of Missouri at the state level, and also in St. Louis and St. Louis County as well. And so I would look out for additional updates from the firm on the Kansas City, Missouri, St. Louis City, and St. Louis County ordinances. So thank you. I think that's it for us on the legal update.
Okay. Well, welcome back to whatever room this is. I am AJ Weissler again. And as I mentioned early on, in between the sessions, we're going to take a break. And this is the first of those breaks. The breaks will be roughly 10 minutes. So if you need to step away, this would be a great time to do so. And for those of you who stick around, don't worry, you will not be without some content that I think will be hopefully useful to you in either your professional or your personal lives. And during this break in particular, we're going to be talking about the great state of California. You were told at the beginning of this presentation that this webinar is being presented by attorneys from Husch Blackwell's St. Louis office, and that is true. And we are focusing primarily on federal law and the states around us. But we all experience and deal with California law fairly frequently. As many of you, if you have operations or employees out in California, know there are some compliance challenges that are unique to that area. And an exciting development that took place earlier this year that also has California on our mind is that Husch Blackwell expanded its footprint in California to add 2 offices to the office we already had. So now we have an office in Sacramento, we have one in San Francisco and in Los Angeles. And we did that by adding a group of over 20 attorneys who have joined our firm and primarily focus in litigation. Many of them do have employment experience, and it certainly expands our capabilities out there. And even before we added those attorneys, we had some capabilities in California. In fact, we had 2 Husch Blackwell California employment attorneys. Both of them are based in Los Angeles, and their names are Jennifer Hines and Amberly Morgan. Some of you may have already had the opportunity to work with them, and they are a fantastic resource for our clients who have issues that arise either on an advising or on a litigation base out there. When I mentioned that we do a lot of California work, even from St. Louis, I'm an attorney in the Midwest, and I actually took the California bar earlier this year. Because of the expansive, role that plays in our firm and the amount of work we do out there, and I passed. That's a subtle brag. I don't get an opportunity to say that to large groups of people very often. I'm not yet licensed in California because I haven't gotten my driving records from Texas yet. So please don't tell your friends that I'm licensed in California. So we're going to add kind of a bonus legal alert, I guess we'll call it. Something that you heard about federal law, Missouri law, Illinois law, some Kansas law. We're going to mix in some California law here. And California law is very challenging for employers. It's very challenging for individuals who live out there. And there are a lot of laws that have sort of some unique characteristics and some challenges. And so I wanted to highlight 6 or so of those, things that maybe you haven't thought about, things that maybe you weren't expecting. And again, this will help you, 1, if you have operations out there, and 2, it will help you in the event that you find yourself traveling in California. There are some guidelines that you should be aware of. So the first law I want to talk about is that in California, it is illegal for women to drive vehicles sorry, I didn't get it all on the first slide, to drive vehicles while wearing a house coat. Now, it's possible that this is a vestigial old law that is on the books but isn't enforced. And if it is ever enforced, I'm not so sure it has the constitutional standing to survive. But do you want to be the person who's driving a vehicle in your house coat that becomes the face of a lawsuit you're trying to strike down this law? Probably not. And so in addition to identifying that these laws exist, I did want to throw out, some compliance options and some help thinking through, how is it that you can avoid being the individual who tests whether or not California can make it unlawful for women to drive vehicles while wearing a house coat. And so there obviously you have lots of options. We keep this presentation mostly G-rated, so we won't talk about whether you can drive it without a house coat. But instead we'll talk about maybe wearing other clothes or having a man drive or just taking, an Uber or some other vehicle. These are all good options. Now, the next law I want to talk about is one that is unique to San Diego. And this is actually the first of several laws that I think makes a little bit of sense. And that is that in San Diego, if you are a homeowner, it's silent about renters, but if you're a homeowner and you put out Christmas lights and you leave them out past February 2nd, you are subject to a fine. And again, that's maybe seems a little bit harsh, but also we all know that some people do put up, garish Christmas light displays. This is a picture of my house from just a couple days ago. And sometimes they leave them up longer than they should. And so you're probably thinking, well, what's the compliance option there? If you put up Christmas lights and they look this good, you're not going to want to take them down after just 3 or 4 months of display, right? Instead, you want to leave them up at least into February. And when I thought about this law, the date February 2nd actually clicked pretty hard for me because the law says you can't leave up Christmas lights past February 2nd. But everybody knows February 2nd is a holiday of similar importance. And of course, it's Groundhog's Day. And so the easy fix to having Christmas lights up past February 2nd is to simply turn them into Groundhog Day. And the fact that you can Google and find numerous inflatable groundhog pictures on the internet is a reminder of how wonderful it is to live in the 21st century. So the next law it comes out of Berkeley, California. And in Berkeley, it is illegal to whistle for a lost canary before 7 a.m. Seems pretty specific. Seems like there may have been a set of facts back in the day that bothered a really specific group of people in the Berkeley City Council. But that's the law, all right? And it's a challenge because if you're going to be in Berkeley, you're going to want to bring your canary. And if you're going to have your canary, there's a chance it gets lost. And if it gets lost, you're going to be looking for it before 7 a.m. because those are prime canary hunting times. But you also don't want to unintentionally stumble into whistling during that time. So my compliance recommendation for here is to follow the law by thinking, well, how do I remember that? And I set up a simple solution, right, is I opened up and created just a simple Outlook calendar that tells me, before 7 a.m., don't whistle for the canary. After 7 a.m., go ahead and whistle. And you'll also notice for those of you who are really savvy Outlook users, I've set it up where the morning session, the non-whistling actually shows that I'm free so that, my colleagues and clients know that I'm not busy at that moment whistling. But of course, I do block off the rest of the day. So the next law we want to talk about is that in Los Angeles, you may not hunt moths under street lamps. So there's a lot to unpack there, right? But I think it's it's focused mostly on the lobbying that must have taken place in the city council in Los Angeles to get this particular law placed in there. It's a very anti-frog, very anti-lizard litigation or law, but it's very pro-moth. And I actually did some research and some digging. So here's a picture that's on the public website of the Los Angeles City Council that passed this law or presumably did so. And I noticed something in the corner, the bottom right corner, that seemed a little bit odd to me. So I did some further digging and actually found a broader picture of the Los Angeles City Council meeting that year. And that is not in the right side of your screen. That is not a city council member, but instead that's a very famous and very, very influential lobbyist that spent some time in Los Angeles, pushing for moth rights. And finally, or I should say finally, next in California, in Walnut, California, it is unlawful to fly a kite higher than 10 feet off the ground. Now, presumably that's the kite that's flying higher than 10 feet. I don't think it's you being dragged more than 10 feet into the air. And this is another one that is one that we recommend you simply comply with, right? Jail time, fines over flying a kite at a height beyond 10 feet is probably just not worth it. And there's actually a pretty long track record of celebrities and other people who didn't heed that warning and found themselves in some trouble. So here's the Bankses, the Mr. and Mrs. Banks from the Mary Poppins movie that was popular in the 1960s. And sadly, their choice to let's go fly a kite in Walnut, California, placed them behind bars. Next up, we have the titular character from The Kite Runner, a popular book by an Afghan-American author that describes the turbulent youth of the child who was growing up in Afghanistan. And what it's actually something that's excluded from The Kite Runner, but it's something I found is that actually when he visited Walnut, California, couldn't resist the urge to fly his kite. Not all kite flying celebrities, however, have come under this law. For example, Charlie Brown, who went to fly a kite in Walnut, California, was not placed behind bars because anybody who knows the character Charlie Brown knows that kite never got 10 feet above the ground. And then finally now, the last law is that in Blythe, California, you are only permitted to wear cowboy boots if you own at least 2 cows. And I've mentioned before that I thought there were a few of these laws that did make a little bit of sense. And this is one I think I can get behind. Because I think we have, as a society, gone too far from associating cowboy boots with somebody who actually wears, or owns, I should say, cows. Right? And so too many people want to take advantage of that lifestyle without committing to it, both in their footwear and in their lifestyle. But at the same time, I'm somebody who occasionally looks pretty good in a pair of cowboy boots. I'm not wearing any right now. I'm wearing just regular shoes. So no compliance issues there for me today. But I don't want to wear cowboy boots every day. And I certainly don't want to have to buy cows for the purposes of wearing boots a handful of times. And so I came up with the idea, and I think it's a pretty ingenious one, which is, there are a number of items out there in the world that people own for a period of time, right? So I thought of timeshares, which I have sat through many presentations about in the past, and thought, wouldn't it be great if you could create a fractional ownership of a cow that you could own on certain days when you had an outfit that would look particularly good with boots and you had a reason to be in Blythe, California. And so, of course, as is typical in these presentations, I fired up the Google machine and I searched for it, and unbelievably did not have to look too far before I actually found a company that creates and has a platform for the fractional ownership of cows. And I don't know if there's a direct link between this website and Blythe, California's law. I don't think so, because the website spells the word labor with a U, which makes me think it's on a different side of the ocean than I'm currently on. But it was an interesting idea. And it also causes me to think that maybe we need to shift a little bit of that saying that my mom used to always say, and I don't exactly remember what it meant. But certainly you want to be thoughtful about, that there's no reason to buy a fractional ownership of the cow if you're already getting a fractional amount of the milk for free. And so with that, we're going to move on to our next presentation, which has very little to do with the fractional ownership of cows and a lot to do with vaccines in the workplace. And we're going to send it to Bob Tomaso.
Good morning. Before we get started, I'd like to make sure that you all know why we've had AJ work remotely since he was a summer associate. And if you saw that presentation, now you know why. I'm Bob Tomaso, an employment lawyer here at Husch Blackwell and office managing partner. With me to present on COVID-19 vaccines in your workforce are Brittany Falkowski and Kayla Lovelace. And thank you for attending today. So I have to tell you, in 32 years of practicing law, this issue is probably the most fluid that we've ever dealt with. It is being handled in real time. The law could change today. And it's also probably one of the most unpredictable in the sense of how employers have approached the way that they're addressing vaccines in the workplace. We have, look, I manage a large office. I see what you see managing your businesses. And we have partners who've said things like, I want everybody who's been vaccinated to wear the scarlet letter. I want a note on them. We have people who say, I want everybody who's not vaccinated to have to wear something. I don't believe the honor system. So it just creates all kinds of incentives. And also realize that probably more so than any time that I can remember in 32 years of practice, we are in a seller's market. If you consider the employee being the seller of their labor, it is very hard right now to find workers. And you can probably tell by the quality of these presentations. We're having trouble finding lawyers. I'm looking around a room full of IT people, and I don't know how these people ever found a job. We're obviously having trouble finding IT people. And that gives a lot of incentives or a lot of power to the employee. And so you've got to be concerned. Most of our clients have said, yeah, in a perfect world, I might require everybody to have the vaccine. But if I do that, I'm probably going to lose out on some good employees. So to answer the first question, let me tell you what we'll cover, and that is we'll cover whether you can mandate vaccines and what are the relevant considerations. I've just given you a few. We'll cover incentivizing employees to get vaccinated, whether you can do that and how you can do that, whether you can require proof of vaccination from employees, and whether you can separate vaccinated and unvaccinated employees. We'll also talk about the treatment of those vaccinated employees. Now, the first question, can employers mandate that employees get vaccinated? The simple answer is yes. The EEOC has said so. CDC has all but said so, right? If you think back to the CDC's order, I think the week leading up to Memorial Day, I thought it was very well timed. And clearly what, to me, the government has been doing is encouraging people to get vaccinated. I think back to what the CDC said. It was, if you're indoors and you are vaccinated, you may be around other people who are also vaccinated without a mask, as we are now, because we've all been vaccinated. That to me was a clear sign that CDC was pushing people to get vaccinated. I know at our law firm, we track this on a voluntary basis, and we're well over 75% of our employees being vaccinated in this office alone. In mandating vaccination, though, it's important to realize that while you can do it, there are some states, like Montana, that prohibits employers from mandating the vaccine. And also, as Brittany will explain a little bit, employers must still accommodate disability-related objections. If the regular flu vaccine caused someone to get Bell's palsy, for example, you couldn't require that person to get vaccinated for COVID. And of course, there are some religious objections that also come into play. Brittany?
Thanks, Bob. Yeah, so for those of you who are not practicing labor and employment attorneys or who are not HR professionals but joining us today, just by way of some background, the law that prohibits employers from discriminating against employees based on their disabilities is the Americans with Disabilities Act. And there are also a lot of analogous state laws like the Missouri Human Rights Act. And in addition to prohibiting employers from discriminating against employees who have disabilities, these laws also require that that employers accommodate their employees. And so in the context of a mandatory vaccine policy, the accommodation that a lot of employees will be asking for is an exemption from the policy. They don't want to get vaccinated. And that's for exactly the reason that Bob just mentioned. They might have some sort of reaction to the vaccine, or their doctor has otherwise indicated that it's not safe for them to take. And so if you decide that you want to implement a mandatory vaccination policy, then you want to make sure that you have a process in place for employees to seek accommodations. And these accommodations are going to be very, very familiar to, I would hope, almost anybody who's had a job in the last 15 months. They're going to be either telework, or if telework's not a possibility, then perhaps a strict masking requirement, combined with perhaps the requirement that they socially distance and also maybe even regularly get tested for COVID-19. And then that way you can still have people who are not vaccinated come into work and continue working. What the EEOC has said, and some of the guidance that's mentioned at the bottom of this screen, is that you can't exclude somebody from the workforce if you have a mandatory vaccination policy, unless you're going to be able to show either that it would be an undue hardship to reasonably accommodate them, or that they pose a direct threat. Now, I think the most important thing to know about the undue hardship analysis is that it is a super high burden for employers. I mean, we have defended numerous disability discrimination claims, and almost never on the basis of undue hardship, because it is just such a high bar for employers to meet. The direct threat analysis, however, I think would be probably lower in this context. At least it was a few months ago, because the EEOC came out a few months ago with some of their pandemic preparedness guidance and said that employers should consider COVID-19 a direct threat to the workforce. As we see more people get vaccinated and as we see cases decline, I think that that will be a harder and harder argument. And so we're definitely going to be keeping an eye on that. And it's, again, goes back to what kind of Bob was saying in the introduction, that this is a fluid situation, and we're commenting right now on something that's changing almost daily. And we'll get to more of that in a minute. But The other type of objection that you'll see if you have a mandatory vaccination policy is going to come under Title VII, and again, analogous state laws, where employers are not permitted to discriminate against individuals based on their sincerely held religious beliefs. And so if an employee comes and asks for an accommodation in the form of an exemption from your mandatory vaccination policy, and their reason is, look, it's against my religious beliefs to get this vaccine, then employers do have to accommodate that, potentially with an exemption and a reasonable accommodation. Same types of reasonable accommodations that you'll see that were just discussed under the disability analysis. So again, making sure that, if you can work from home, then you're giving employees an opportunity to do that, perhaps masking, testing, things like that. Now, the thing to remember that's different about Title VII and the ADA is that there is a similar undue hardship analysis, but the bar is much lower. And so COVID-19 spreading could be an undue hardship under the Title VII analysis. But again, it's going to be one of those things that's going to be very fact specific. And perhaps now that we're seeing cases decline, will be less likely of an argument that we'll see hold up in court. So the last bullet point, I think, is really the one that has been on a lot of employers' radars as they are considering mandatory vaccination policies. And that's, what can we ask our employees to provide to make sure that it really is a legitimate request, to make sure that their religion really does prohibit them from getting the vaccine. And the EEOC's guidance has specifically said that you can request supporting documentation when there's an objective basis to question the sincerity of the belief. So what is an objective basis? Perhaps if you overheard the employee indicate to their coworkers, look, I don't want to get this vaccine. I think it's just the government trying to chip me, something like that. And then they say, actually, I'm just going to submit a request for a reasonable accommodation. That might be too good to be true in terms of, I don't know if any employer will actually overhear that kind of conversation, but there are probably other situations that would arise. And if you have an objective basis to question the sincerity of the belief, then you can ask for that documentation. So what are the legal claims that are arising? This is a question that I know a lot of us have been getting, and we're basically being asked, what's my risk of liability if I implement a mandatory vaccination policy? Well, there's a case that we've been keeping an eye on. It is Jennifer Bridges versus Houston Methodist. It was pending in the Southern District of Texas until this last Saturday, when there was a recent decision by the judge to dismiss the case. And so basically what the employees were claiming, well, first, I guess, the hospital had a mandatory vaccination policy, right? So otherwise we wouldn't be talking about this case. They implemented the policy and then immediately had the employees who did not want to get vaccinated, and it was not related to disability-related reasons or religious-related reasons. It was just a variety of reasons. They said they don't want to get vaccinated, and it would be wrongful in violation of public policy to discharge them for refusing to take an experimental vaccine. There were a lot of salacious allegations in the petition. The employees likened their treatment to human guinea pigs, things like that. And so at first, the judge denied the workers' temporary restraining order to block the hospital from even having such a policy. They said, look, there's more of a public interest in having a safe hospital than the vaccination preference of 117 people. And then on Friday, there was an oral argument related to the hospital's motion to dismiss. And the hospital argued there's not been a wrongful discharge in violation of public policy because we have to actually ask our employees to do something illegal in order for that claim to be valid, to be one that the employees can assert. And the judge absolutely agreed in a pretty fiery 5-page opinion that he issued on a Saturday, which I've never had a judge issue an opinion for me on a Saturday. Must have been something that he felt very strongly about. But he called some of the plaintiffs' arguments reprehensible and said, look, you don't have to get the vaccine, but then you can also just go work somewhere else. And that was essentially the long and short of the 5 pages. And I think it's a good case for employers as we're navigating this in real time. And now we kind of have at least some precedent to rely on in the wake of what we kind of envisioned would be a lot of individuals' claims. There's another case that we're also keeping an eye on. This one was just filed in June 4th, I guess is the date that it was on file. So we don't even have like an answer yet or anything from the employer, but essentially very similar arguments, only this time the employee is claiming it's a waiter who's been subject to a mandatory vaccination policy, and he's claiming that he can't get vaccinated for religious reasons, and that instead of furloughing him, his employer should have just required him to wear a mask and get tested frequently, should have accommodated him in other ways. So we'll definitely keep an eye on this one as well. Finally, before I pass it over to Kayla, one of the things that we just want all of our audience members to keep in mind is that before you consider mandating COVID-19, there are other things beyond legal considerations. There are, considerations about the culture of your company, whether it's potentially going to create a reduction or loss of staff talent. What Bob was mentioning, employees really have the upper hand right now in this market. And so is it a market where you want to start placing a requirement on people and have them, decide that they would rather go work elsewhere because they don't want to be subject to this mandatory COVID-19 vaccination? There's also potential for an unintentional adverse impact on groups who are hesitant to get the vaccine. And so you just want to be careful, especially while the vaccines are experimental, before they get full approval from the FDA, which we hope will be coming soon. But you just want to be careful that you're not alienating your workforce. And so if you have a workforce that you do not think should be one where you would mandate the vaccine, then you can always consider incentivizing, which is what Kayla's going to talk about next.
We should add also, similar to the Texas healthcare case, a St. Louis large healthcare health system implemented mandatory vaccination requirement just this week.
Great, thank you. So like Brittany said, I'm going to talk a little bit about whether employers can actually incentivize the vaccine. The quick answer is that yes, employers may incentivize the vaccine. And just in late May 2021, the Eeoc did issue guidance that cleared businesses to award their employees to get the vaccine from a third party. But because pre-screening COVID vaccine questions do include some disability-related inquiries, they do say that if an employer requires that incentivize an employee to get a vaccine from a third party that the employer contracts with or on site, it does fall within the definition of an incentive wellness program. And we know the previous presentation did talk a little bit about this. However, we're going to go a little bit more into detail. So when getting a shot is the part of a wellness incentive program, basically the award that the employer gives cannot be so substantial as to be coercive. Unfortunately, the Eeoc did not actually give direct examples of what activity or awards will be considered so substantial as to be coercive. However, we do have some evidence from what other large employers have done within this realm. So, for example, Dollar General, Aldi, and Trader Joe's have implemented some incentives for their employees. So we have seen some employers allow their employees to take paid time off to get vaccinated. We've also seen other employers offer cash bonuses or gift cards to their employees if they want to take time off to get that vaccine. Some employers have also hosted vaccine clinics as well, and also others have offered points or credit in wellness programs or made competitions. If you do have employees who are unable to get the vaccine because of religion or disabilities, we do recommend that employers make some type of way that those employees are actually able to get the incentive as well. And I'm going to pass it over to Bob. Thank you.
So now this is very near and dear to me because I've been carrying around my vaccine card. Can employers require proof of vaccination from their employees? Now I got this finished on April 8th. So it's really dog-eared. And my daughters, who think technology is the answer to everything, said, why don't you just take a picture of it, you knucklehead, and keep it on your phone? And so I just did that about 15 minutes ago. But the answer to the question, can employers require proof of vaccines from their employees, is yes. Employers may require proof of vaccination. Now, be sure just to ask for the card itself or a doctor's note, not other medical disability related or genetic information. And if you're copying the card, if the employer's going to copy the card, treat it as a confidential medical record and keep it out of the employee's personnel file in a separate medical file. Also, consider the honor system. It's what we do at the firm, although I've got one partner who says he doesn't believe in it. And also, you could just have an attestation instead, send out a survey. Have you been vaccinated? Let people just write you an email or a note. Could be an affidavit if you want to go that far. Also consider not requiring, but requesting voluntary disclosure to avoid potential privacy-related objections?
Yeah, I think that's a really good point. I've gotten a lot of questions about what to do with proof, and it's been helpful because the EEOC did come out and tell us that if you're collecting either the card or a doctor's note, then you should keep it separate as medical documentation, which I know was kind of a question that we had up in the air for a little while. So the next question is whether employers can physically separate vaccinated and unvaccinated employees in the workplace. And I think I got probably the easiest question here, because the answer that we would give is that is not advised. And it goes back to what I was talking about very initially. Whenever you have employees who may be objecting for disability-related or religious-related reasons, you would hate to separate them in the workplace from people who don't have the same type of protected statuses, and then have an argument that you're treating them differently in the terms and conditions of their employment. And so the obvious and most easy example is if you have 100 employees and 50 of them are vaccinated and 50 of them are not, and you've got 2 floors on a building, or in a building, then you put 50 on one floor, 50 on the other, and you let the vaccinated people take off their masks and meet in person and have parties, and then the unvaccinated people, you say, no, make sure you keep your distance, or actually go home and work from home. You're not allowed to meet with anybody. I think that's a fairly obvious example of something you should not do. The question definitely gets harder, though, and this is something that I've had a lot of clients coming and asking about. What if we just only invite vaccinated people to dinner? Because at dinner, you obviously can't keep your mask on. And so would that be discriminatory? Would we get in trouble? What kind of risk of liability would we have if we only invite vaccinated people to dinner? Or if we only invite vaccinated people to small, client meetings where our clients feel more comfortable to be unmasked with us? And I think, again, the answer is the same, especially when you may not know what the reason is for somebody not getting vaccinated. You wouldn't want to have an adverse impact on a particular group based on treating vaccinated and unvaccinated people differently. Then on top of that, it could just really create, an us versus them issue and negatively impact morale in a way that you really don't want to do during the ongoing pandemic, when so many employees have really relied on their employers as, a place where people, a resource for a lot of help when it comes to just navigating a myriad of issues. So that was sort of the easy one on tap. And then I'll give Kayla the harder one, which is, can employers allow vaccinated employees to stop masking?
So Brittany, we didn't rehearse this, but are you saying then it's probably a bad idea to treat the unvaccinated like we used to treat smokers in airports and put them behind glass like they were zoo animals? I thought it was kind of cool. You wouldn't do that in the workplace?
I would probably advise against it.
Okay,
yeah.
Thank you.
Great,
there you go, Kayla.
And so lastly, we're going to discuss whether or not employers can actually allow vaccinated employees to take off their mask and to stop social distancing within the workplace. So we all may have seen the CDC guidance that said that employers who may allow fully vaccinated employees to actually stop wearing masks and to stop social distancing at work. They define fully vaccinated as someone who is 2 weeks post the second dose of their 2-dose vaccination, or who is 2 weeks post the first dose of a single vaccination. Very recently on June 10th, Osha did implement some guidance. Direct quote, most employers no longer need to take steps to protect their workers from COVID-19 exposure in any workplace or well-defined portions of a workplace where all employees are fully vaccinated. Employers should still take steps to protect unvaccinated or otherwise at-risk workers in their workplaces or well-defined portions of the workplace. And so the rule of thumb would be to stay as close to that CDC guidance and the OSHA guidance whenever reevaluating your mask mandates. And there are some other practicalities to kind of think about. So some employers may consider implementing an honor system, which Bob kind of talked about in a different context, potentially implementing an honor system where, you take your employees' word for the fact that they were vaccinated and they don't have to wear the mask or socially distance. You may also do an anonymous survey where you're asking, how many people have actually got vaccinated, and depending on the percentage, you may reevaluate whether or not employees should be mandated to wear a mask at work. Additionally, you can ask for that proof. We have had some questions about, asking for individuals who are vaccinated to wear stickers or, lanyards that show that they actually got the vaccine. We recommend against that. We don't want to separate, anyone who is not vaccinated because of religious or disability-related reasons. Same for proof. Whenever you do ask for it, try to stay, on the question of whether or not they are vaccinated or not. Don't ask too much as far as the disability goes as well. Employers should also consider how they're going to treat their visitors as well. And so for any employers who are concerned about potential liability who are within Missouri, Missouri recently implemented a SHIELD law. It will go into effect August 28th, 2021. And basically, it prohibits any liability lawsuits against employers in Missouri unless the individual is able to show that, you know, they got sick from COVID at the employer's workplace and that the sickness was as a result of the reckless or willful conduct of the employer. And so that actually concludes our presentation, and we're going to pass it on over to AJ. Thank you.
All right, thank you very much, Kayla. And as before, right, it's time for another break. You've got about 10 minutes or so if you want to step away. And as before, we're going to provide some content for those of you who stick around. So this time, I'm pleased to tell you that we're going to be talking about something that is extremely personal to me, because in addition to being an employment lawyer who's previously in the St. Louis office, I'm now a member of Husch Blackwell's virtual office, which is called The Link. And I actually work remotely and have worked remotely for the last almost 4 years now. And so as many of you are returning back to the office, as many of my colleagues are returning back to the office, don't forget that there are some of us who will remain in a work from home status, potentially forever. And so what I thought about as we were talking about the vaccination presentation, talking about, these issues that employers are dealing with as they bring their workforces back, I started to get a little bit introspective, a little reflective, and I started thinking about what do I miss about working at the office? Like when I work from home, right? What are the top 10 things that I miss about working in an office setting? And so I threw together some slides so that I could, indulge my captive audience with some thoughts about that. And so the first thing that I miss, it's not that cat or that dog. I just sort of included some pictures that sort of remind me or reflect what I miss. And the one thing I miss about being in an office setting, and actually happened today, is that, sort of unique joy that you experience when you're walking down a long hallway and you see a coworker at the far end of it, someone who you only know a little bit, and you lock eyes with them. And you're both walking in the same direction, not at a pace, and you realize that you're going to have to keep eye contact with that person and a gentle smile until you get close enough to say something to them. And I just find that is such an intimate and wonderful experience to share with another human, and I just don't get that when I'm working from home. Another thing that I miss is not cubicles, right? I don't know if anybody misses cubicles, but what I do miss about working from home is how helpful my colleagues can be when they're not interacting with me just virtually, right? There is sort of that personal touch that can happen. And actually the specific thing that I'm thinking about is the joy that you feel when somebody sends you a work-related email. And between the time that your computer chimes that the email came through and before you can even click on it, that same person comes to the door of your office, leans in and asks in person, did you receive my email? That sort of personal touch, that kindness, that thoughtfulness is just not something that's as easy to recreate when you're working from home. And it's something I really do miss. Something else that I miss about working from home, again, kind of fits with that thoughtfulness of your colleagues, is, when you're interacting with people on a daily basis and they really start to care about you as a person, one way they manifest or show that care is by making sure that you make healthy choices. Right. And so if you bring, for example, food from home, or maybe it's leftovers from your lunch the day before, and they're in the fridge, sometimes they worry, maybe that's a little too much for you. Maybe you would do better going without that day. And sometimes they'll even be kind enough to eat that food for you, right? Take those called caloric bullets for their colleague. And that's something that, again, just doesn't happen as often when you're working from home. Doesn't happen never from home. I have kids and spouses who occasionally help me with this. But that's another thing that I miss, at least, working from home. Another thing that I miss working from home, and this picture on the slide sort of matches the futuristic office setup that we have here, and that is the joy of getting onto an elevator with somebody and knowing that you've got 10, 15, 20, depending on how many times it stops, seconds to really connect with that person, to get deep inside of how their day is going, to have them ask you how your day is going, to try to remember some fact about that person from the last time that you rode the elevator together, and to connect. And it's life is about those little moments of connection and the chance to have that. And again, I just don't get that. I just don't get that from home. Something else that I miss about working from home is how often communal food will just sort of appear, right? And some people are thoughtful enough, again, I think looking out for your caloric intake, to take a couple of bites to make sure that the donut is good, and then to leave it behind so you know when you get to the box, that this is a donut that somebody else has appreciated and experienced. Now, granted, in a pre-COVID world, this picture wouldn't cause me to have the same strong reaction that I'm having to it in a COVID world. But at the same time, I would still rather eat a half-eaten glazed donut before ever eating a cream-filled. But that's just me. And again, this presentation is all about, about me and my personal beliefs. Another thing that I miss, number 5 thing that I miss while working from home is just that sound of laughter. It's actually something that I miss doing these presentations virtually, because think about how loudly each of you are laughing in your own offices and homes right now, and how wonderful that would sound if you were all in the same room with me and we were all laughing together. That's something I miss, right? Is going to work, talking to your colleagues and hearing them just laugh like crazy at the things that you say. Actually, as I realized, I think I picked the wrong slide for this one, so I'll click it to the next one. Sorry, I unintentionally cropped out. Because really what I miss is that sound of fake laughter, right? The sound that when you tell a joke to people who are dependent on you for work and their livelihood, the particular brand of laughter that you get from those people. It's something that I've experienced. Bob Tomaso, as you saw earlier, occasionally says things that he thinks are funny. And I've done a very good job of laughing in a way that I think conveys to him that I also think they're funny. And that's a sound that I miss when I work from home. Another thing that I miss when working from home are the people, the coworkers who are thoughtful enough to think about the full immersive experience of working in an office, which is not just the sights and the sounds, but it's also the smell, right? And so I used to have an office that was just down the hall from a microwave. That microwave was regularly used by individuals to heat up their lunches, sometimes my lunch. And sometimes those lunches included things like seafood or tuna. And that smell fills the office, gets into your pores, and reminds you that you're all in this together. And so, the picture is actually a real thing. You can take a can of oil tuna, you can poke a hole in it and put a candle wick in it, and that sucker will burn for hours. And not only will it burn for hours, it will fill your house with the same thoughtful smell that your colleagues occasionally fill the office. And it's just a wonderful thing, and it's something I definitely miss while working from home. Something else I miss from working from home, this is where I get a little self-conscious and I hide my hands behind my computer. Because when you're working from home, you don't get the same reminders about hygiene that you do when you're working in an office. I've had colleagues, I'm sure you have as well, that know the importance of keeping your finger and toenails closely trimmed. And the easiest way to alert you and the others around you to that is that nice sound that you can all hear if you think about it right now, of somebody somewhere near you clipping their fingernails and toenails. And so you hear that sound, it reminds you, you know what? Thank goodness that I heard that. I need to trim my toenails and my fingernails. And then you pay that forward by doing it as well. And that's something that, again, you just don't get that from home, right? This is something that I definitely miss from being in the office, and it's something that I'm sure you all appreciate for those of you who have returned. So number 2 thing I miss while working from home. So for those of you who are joining us from outside of the St. Louis Metro, this is a picture of the St. Louis Metro. And those are highways, and those highways are color-coded, orange and red and dark red. And of course, then there's a little bit of green if you squint. And those colors, of course, reflect something that I definitely miss, and that is commuting traffic. So I used to live across the river in Edwardsville, Illinois. I had about a 45-minute drive on a day where everything went perfectly well, and about an hour and a half drive on days where it didn't go as well. And I miss that commuting time. I miss the opportunity to make eye contact with individuals who are texting and see me at the last moment and swerve out of my lane. I miss the chance to listen to talk radio, to listen to podcasts, to be on the phone, to eat the food that I don't want to leave in the refrigerator for fear that it will be eaten later in the day. That's just something that you don't have. I recreate it as much as I can at my home. I walk into and out of my garage to start every day. I find other ways to get my blood pressure up as high as I possibly can before starting the workday. Because if your start of the day is stressful, difficult, and time-consuming, all of the rest of it feels so much easier, so much better. And that's something you just don't get when you work from home, where your mornings are pleasant, where people are making you coffee and bringing you breakfast to bed, which I'm sure has been your experience working from home. It certainly is mine. And so I miss the opportunity to sit in traffic that is provided when you get to return to the office. And this is a real, for those of you who are wondering, a real rendering of the traffic that occurred the last time that it snowed in St. Louis. And that's something else that I miss, right, is having weather determine so strongly how my morning was going to go. And then the final thing that I miss, the number one thing that I miss about working from home is a little bit cheesy, I'll admit, right? Because the number one thing that I miss, of course, is the camaraderie, right? It's the coworkers, it's my wonderful colleagues in the St. Louis Labor and Employment Group, and that's probably easily the thing that I miss the most. And you've obviously gotten to experience some of them already today, and you'll get to experience some others. But then I can also hear some of you out there in virtual land, not actually hear you because I don't get to hear your sound, you don't have your mics on, but I can sense that you're thinking, what a cop-out, right? What a cheap ploy. What a to say that the number one thing that you miss while working from home is this whole group of people. And I have to admit, you're right? It's not appropriate, it's not fair for me to do it that way. What I really should do, and I have, right, is single one person out, right? And so that person, of course, and you probably already guessed it, is Carrie Claiborne, right? And so what is the number one thing that I miss while working from home? It's Carrie Claiborne, because she's wonderful, she's smart, she's insightful, and she actually is the presenter who's leading the panel on the next presentation. And so without further ado, I'll be sending it over to Carrie Claiborne and our panel to discuss cultural competencies, and we'll find out if Carrie lives up to the expectations that I've just set for her as the best person in the St. Louis Labor and Employment Office. Thank you.
Hi, this is Carrie Claiborne. I just heard my name. I did not hear all the expectations AJ just set out for me, so I will surely satisfy them, though. I'm a labor and employment attorney here in the St. Louis office, and with me over to my far right is Sunny Nolan also. She is a partner in the Husch Blackwell St. Louis office, practices in labor and employment. Before coming to the firm, Sunny also was an in-house attorney for about 10 years, also handling all issues labor and employment. And then Sunny and I are very excited to be here also with our guest today, Professor Kim Norwood. She is a Henry H. Oberschelp Professor of Law at Washington University Law School. And her research focuses on bias, also Black think, colorism, implicit bias, and the intersection of race, class, and public education in America. So you can probably guess why we have her with us here today for this topic, which is elimination of bias, best practices for developing cultural competency in your workplace. We're so happy to have you joining us. And what we're going to do today, there you see us, we are going to get Sunny's perspective as a legal practitioner. I'll throw in my perspective at times, and then we are going to hear from Professor Norwood to get her academic, the broader cultural perspective on elimination of bias, which I should say right up front, it's not really a debate. We can't actually eliminate bias, but we are trying. So if AJ set out the expectation that I was going to eliminate bias, I will not. But you'll hear more about that from Professor Norwood. And as we get these perspectives from these two, we are going to walk through it in three parts. First, what is bias? Second, why does it matter? And then third, we'll talk more about strategies and insights into addressing bias in your workplace. First, what is bias? I think many of you in this audience have likely heard the term bias or even implicit bias. And what I'm hoping to do with that, knowing that you kind of know what this is to talk through some of these terms, get Professor Norwood to give us a little historical background to make sure we're all talking about the same things. So Professor Norwood, thank you.
Thank you.
Can you talk about how we got here?
Yes, a little bit. Yeah, thank you. I'm happy to be here. I want to sort of thank everyone, Shana, Carrie, Sunny, for inviting me to this. This is really, really cool. Thank you. So how we got here. What I thought I would do the other day, my husband and I were watching a movie called The Terminator. I don't know if you've ever heard of that movie. I don't know how old my audience is, but it's a movie about a machine who goes back in time, to like sort of kill this person, right? And that machine looks like a human. It looks like Arnold Schwarzenegger. But one of the things that happens throughout this movie is that whenever the Terminator, this machine, sees something, you can see the mind sort of registering and quickly deciding, is this an enemy? Is this not? What do I do about this? What do I do about that? Do I go here? Is this a danger? And really, that's exactly what our mind does, right? Very quickly, very efficiently, we almost have brains like the Terminator, which is kind of scary, right? So that's important, right? Because one of the things that we see that happens in this particularly unconscious implicit bias space is that automatically your mind is registering in milliseconds before you've had a chance to think about it and slow it down, right? And so sometimes that's good and sometimes it's not, right? And so how does this happen? Where does it come from? Well, it turns out we are born like this, right? According to scientists, in order to function, we have to make decisions really, really quickly, right? And this comes back, this is thousands of years, right? And so our minds are automatically wired for this. So some of it is biological. And then we also have this other piece which is environmental. So I have this slide here, and I have some images that I want to talk through to give you an example. One of the first images on this slide is this question about, are babies racist? I get it. The title is problematic, right? But what the research has found is that infants as young as 6 to 9 months automatically prefer people who have the same skin color that they do. Right? So they're not bigots. They're not, right? Like they're not these horrible people. These are babies. But they absolutely have an affinity for people who they feel comfortable with. And that turns out to be people who they think have the same skin that they do. So that's the biological piece. But then we have another piece, right? We have a piece that is environmental. One of the next images here is a YouTube commercial from this sanitary napkin product, Always. And they interviewed some girls, and they asked these girls to do different things. And one of the prompts was to throw like a girl. Another prompt was to run like a girl. And what they saw in these commercials was just phenomenal. What they saw is that if you were 10 and under, this girl used all of her energy to throw as hard as she could. And she danced with all the joy that you would imagine. But by the time after puberty, by the time she got to be 17, 18, she didn't do that. She really pulled back substantially. And so Always is saying, wait a minute, what's going on? What messages are we sending these girls, right? So that they change from this, I'm going to do it, I'm great, right, to, ooh, I'm weak and I need help, right? There's something in the environment that's causing that, right? And so we've got some environmental stuff. The book that I have here, Cast by Isabel Wilkerson, talks about a lot of things that have happened over the past 400 years in our society that sort of plays into this idea about messaging, about what people can do, who they are. That becomes embedded in the mind. And even today, we continue to follow those sort of stereotypes. I have this really, the last image that I want to make sure I talk about is this really interesting thing that happens when, as a result of norms, right? Expectations, there's a default in our system, right? So my husband and I just got back from Jamaica last week. We were celebrating our 33rd wedding anniversary. And I planned the trip and I paid for the trip, and I was the person who did all the emails. My first name is Kimberly. And as you can see from the email and all of them came back Mr. Norwood. Right? So I felt a kind of way about that, right? But the other thing is like, well, why is that? There's a default. We've come from a place where historically men were the ones who were paying and doing these things, and our system is on automatic pilot, right? And despite the fact that things are different, the machine doesn't know that yet. So it's defaulted to automatically go to the male. Right. And so I have this all the time. I bought a car a few years ago. Same thing. Didn't matter. Mr. Kim Norwood. Right. And so these kinds of things happen because of our environment, what we're in, what we're breathing in. Not only just what we see in the streets, but look at this image in the middle where we talk about there's a cartoon called The Simpsons, right? Was on for decades. And this particular actor played an Indian man who owned a store. And he did this for 30 years. And he had no idea that it involved a lot of stereotypes. And it wasn't until fast forward years later when he's at a school, his son's school, delivering, a message. He had an Indian student come up to him crying, saying, why are you doing this? This image that you're playing, even though it's a cartoon, people somehow are digesting these stereotypes as truth. You have to stop doing that. And so he writes this piece in the New York Times saying, wow, I never knew that this was happening and I apologize. So we're engaging in these behaviors, right? And we don't even sort of realize the harm. The last image there is the Band-Aid, right, which is a nude color. It's not my nude. There's a default, right? And these are norms, right? And so this becomes something that we have to disrupt because otherwise people get left out. So back in 2015, Paulette Brown was the first Black female president of the American Bar Association, and I became active with the bar at that time. And she created a commission to look at DEI issues. And so we spent a year taking a deep dive looking at these issues. We came up with some ideas, which included, among other things, an amendment to the CLE, the Model Rules of Professional Conduct, which would require some bias training of lawyers. The ABA ran with that, and eventually, I think it was by the end of 2015, the ABA enacted a resolution that requires all kinds of DEI amendments. And this particular one was picked up by the Supreme Court of Missouri. Many courts, many states around the country actually have now adopted that ABA resolution, which requires some training of lawyers who are looking for ethics credit. And so it's only, I think, an hour. Did you see that? At least 1 hour. But and so I'm pushing for more. But we at least have that now. And so states around the country have adopted that resolution, and hopefully lawyers will follow up on this. I want to end with saying our profession has been a little bit slow in this area. We've seen tremendous efforts to disrupt biases in the medical profession and in other industries. And law has been slow to this. So I was really excited that the Missouri Supreme Court adopted it, and hopefully we will go further.
That's great. Well, the historical context and that information is really interesting. I know I also read one of the books that you had on there was Cast, and I just found that to be phenomenal. So anyone who hasn't read it, this goes very well with what we'll continue to discuss today, but improving our cultural competency is a big part of addressing bias, continuing to educate ourselves. And also next, now we're not going to go, you can see this slide is full of words, but I was hoping Professor Norwood would at least just kind of touch on what these terms mean. before we dig in a little bit, because these are terms I think people start to throw around, but it's,
Don't really
just to make
realize,
sure we're on the same page.
And there's so many terms, right? So this, you can read this slide later. I think it'll be available. We're talking about bias today, right? And so bias is attitudes and stereotypes that can affect your behavior. It can affect your thinking. And what we see is that biases can be explicit and they can be implicit. Explicit biases are conscious, they're known to you. Think of, they're more intentional. You've thought about it often when you're talking about an explicit bias. So the imagery that I'd like you to think of is a tortoise, right? Walking really slowly, Complete opposite from implicit bias, which is very fast. You're not even thinking at all. You're in an automatic mode. And I often talk to people about how sometimes when I used to go to WashU to work and go home, sometimes I would say, I'm going to stop at the cleaners, right? And the next thing I know, I'm in my garage, right? Like I'm on automatic pilot, right? And that's how sometimes implicit bias works. You're not really thinking about it. It's automatic, right? And so that's what the distinction that we're trying to make. Explicit bias has been addressed by the law for many years, right? When you think about racial discrimination, gender discrimination. Implicit bias is harder, right? Because it's unconscious. So we have more trouble in that space, and Sun will get into that, I think, a little bit later. And so I wanted to give you an example of the difference between bias and discrimination. So I have 4 kids. And so I like all of my kids better than your kids, right? Like, so that's a bias, right?
You've never met my kids.
Yeah, but I like mine better, right? And so now let us suppose that our kids are going to interview for a job that I am going to, I'm looking for some help this summer, and I'm going to interview your kid and I'm going to interview my kid. And I already kind of like my girl, right? But if I choose my kid over Carrie's kid, that's the Discrimination Act. That's acting on the bias. Mm-hmm. So it's discrimination is sort of an aggravated form of bias, if you will. And so and so there's also legal discrimination, right? What I did isn't actionable, right? I don't think.
Depends,
yeah. It depends on how many employees you have.
Right. Right.
Yeah.
Oh, I love that.
Yeah.
Well, that's okay. So let's see. Before we get into the unlawful discrimination, like you referred to, which Sunny is going to talk about. She's patiently waiting over here. But
I love this topic, though. Love hearing about it.
Before we do that, just one other term, because I know I've heard this term a lot. I think a lot of people have heard it, and it comes up in the workplace quite often now. I've heard it in a lot of investigations or even charges and lawsuits, but the term is microaggressions. So if you could comment on that a little bit.
Yeah. And again, we have the slide here, which does a really good job. Microaggressions are these subtle, here that you have 2 definitions. They're subtle acts, sometimes nonverbal, but even often verbal, and they land on the target in a way that Maya Angelou would describe as death by 1,000 cuts, right? Mm-hmm. Like you get these little ways in which people will say things that attack your humanity, your personhood, even though they don't realize that they've done that, right? Mm-hmm. So some of the examples here, when we say to an Asian American person, where are you really from? Right? That's kind of like a microaggression, right? It's making an assumption and acting on it, and it lands on that person in a way that's harmful, right? That's hurtful. I just had this happen to me when we went to Jamaica. I'm going up first class, right, to give my ticket, and the person says, oh, wait, we're only boarding first class. That was a microaggression. It was an assumption based on looking at me, but it hits me in a way that's hurtful. right? So these are microaggressions. The one thing I did want to point out about this term microaggression is that micro doesn't mean small, right? Micro means every day. It means individual actions that people are going through. So don't, these could be, microaggressions could be big things. Like if you call somebody a racial slur, right? That's not micro in that sense of the way in which we would define it typically, right? But it is an aggressive attack on a person. That's what we would call a micro assault, for example. Most of our microaggressions are not that overt. Most of them are more, I didn't even know, right? Like if you ask a person to tell us, only Black person in the class, in a given class, and that person is asked to tell us what Black America thinks about X, right? That's an assumption, and it's offensive, right, to the person who's thrown that question. So there are different kinds of microaggressions, and all of them are housed in bias and could be explicit or implicit.
Okay, great. Thank you. And we will talk more about them throughout the discussion, but important terms for us to know. So next, moving on, because we're going to talk a little bit now about why it matters. So getting, again, the perspective of both of you, I'm going to start with Sunny, asking you from a legal practitioner's perspective, as many people may know, and Professor Norwood referenced, bias is not the same as unlawful discrimination. So from your perspective, Sunny, as outside counsel now, why does it matter even if bias is not actually or technically discrimination?
Sure, yes. Well, and it is really important that people understand that not all bias is discrimination, certainly, but bias can lead to discrimination, or it certainly can lead to the perception of discrimination. It can be used in litigation to show discrimination in a broader context, so lots of small or what are perceived as small issues coming together to show prejudice or discrimination. It's also important that individuals look at bias in the workplace because the employer's policies typically have a higher standard than the law. And because they have a higher standard than the law, they have to take action before it becomes illegal discrimination. And that really is critical. You need to make sure that you're taking that action before it becomes illegal discrimination. And one more piece is that there's a really important affirmative defense, a defense to a charge of discrimination or a lawsuit that employers lose if they're not recognizing bias, if they're not training about bias, if they don't have good reporting on just bias, not necessarily discrimination. So they miss a really important opportunity to defend against litigation, but also to address issues in their workplace before they become something outside of their workplace.
So that last thing you said, it says on the slide also, and you mentioned issues with overlooked bias. So I guess, are you saying that there are times when something that may just be evidence of bias, not necessarily unlawful, could either ultimately become unlawful? Do you have examples, or, can you speak to some examples you've seen in workplaces or in your practice?
Absolutely. One thing I definitely want the audience to take away is what was considered appropriate 5 years ago, 2 years ago, 1 year ago. It's changed. And what a jury might not have considered bias or discrimination 5 years ago, a jury today may consider it discrimination. One example is the Confederate flag and different parts of the country and how, that is perceived. But what if someone has it on their license plate, it's their personal car? Does an employer have an obligation to address that? They don't have anything to do with this car, but the car is in their parking lot where customers may come in, and certainly where their employees are seeing this. And these are all real life situations. Just to be clear, the ones that Carrie and I are giving are really from our practice. I mean, from our clients. Another one is the head of HR having a Bible in their office. Certainly did not mean anything negative and didn't want his office to not be an inviting place for someone who wasn't Christian, but that did come up, as an issue to those who either, don't practice Christianity or, practice no religion at all. And whether or not that leader of HR is someone that they could talk to openly about different issues that may not line up with Christianity. Another one, and this is a really difficult one, and I think over the last year it's become even more difficult maybe, and that is a situation where, and Professor Norwood touched on this, where someone actually wants to be more open to different points of view, wants to go out and ask people for a different point of view, and so might come to a young African-American woman in the workplace, new to her position, and say, hey, this happened, I'd like to get, the Black person's perspective. And if I say, well, that person was uncomfortable, then the response is, well, but I thought I was supposed to go out and get diverse points of view. If that's offensive, then how do I get diverse points of view? And there are ways, certainly, and one is to make sure people are open to discussing those issues. And there will be some who want to discuss those issues, who really want to engage. And sometimes that same person may not want to. So just making sure that when you are reaching out to individuals for a diverse point of view, that they're willing to give it, and that you're not saying that then stands for everyone's point of view in that group.
Really, those are great examples. And I think uncomfortable situations that a lot of our HR professionals are the ones who are dealing with and managing. We are going to talk more about some tips for addressing bias, but because you raised those particular examples, do you have, I think what people might be wondering is like, wait, am I not supposed to let my HR manager have his Bible in the office?
Right.
What are some thoughts you have on, how they should be thinking about it when they get those types of complaints?
Sure. Well, for one thing, they need to be a safe place for employees to raise that they're uncomfortable and find out why they're uncomfortable. Often when an HR person then goes to the person who has the Bible and says, hey, we'd like you to either not take that off or park your car somewhere else or remove your Bible, and explaining to that person how other people might perceive or how they might be uncomfortable. Honestly, 9 times out of 10, the employee is really willing. They're, oh my gosh, I didn't realize that would be offensive. And in fact, this is what this means to me, and I did not recognize this is what it means to someone else. And that really is a true statement. Just geographically, generationally, what I consider offensive and what, a younger person would consider offensive are very different. They just are, which is why it's critical to get all different kinds of points of view. And HR should be doing the same as should lawyers.
So it depends on the context, and bottom line, don't ignore these things.
That's right.
Yeah.
Even
don't
if you
just
think it's
them
as something small, because it's this and then this and then this, and that makes it suddenly look like it is not a welcoming environment for all races or genders or ages.
And I see this a lot too, where as I interview employees around the country, employees who have left because HR has not addressed issues, right? And so there's a thing there with that, right? Because some people, they're not sure if there's going to be a resolution, but they want it addressed, right? And so when you ignore it, it's a microaggression, right? In a way, right? And it sends a message to that person about whether they belong. And so you see people who leave because they feel that they're being ignored or they're invisible.
That makes sense and is a good segue into what I wanted to ask you about a little more is some perspective. So Sunny, I think what you talked about really goes to from a legal practitioner's perspective, you know, if you overlook these things, you could end up with a lawsuit or you could end up with other issues that are going to be expensive and potentially actually illegal. But on a broader cultural perspective, from you, Professor Norwood, what are, you know, in addition to not wanting to spend lots of time and money on legal battles, what are some other reasons culturally where, you know, it matters addressing these issues, looking at bias in your workplace really does matter?
Yeah. So this slide that we're looking at now comes from leanin.org. They have some phenomenal slides, reports, etc. So please go there and check it out. In this particular pipeline, there's one for law firms, and this one is for corporate America. And what it shows you is entry level up to C-suite, right? And what we see, if we take the first level there, white males are coming in at, I can't read it here, it's maybe 35% or so. And over time, every increment, they increase more and they're taking a bigger part of the pie so that by the time you get to the C-suite, although they started at 35, they're now at 64% of who's in the C-suite. So, and then you look at the other groups, no other group does that, right? The other groups go down. But the thing that this is on a Lean-In website, and Lean-In is really sort of focused on what happens with women, right, in these spaces. And one of the things Lean-In would say to you, and I agree with it completely, is that if you're a woman coming into an environment and you're looking at this data, you're kind of worried, right, about whether you are going to be able to make the C-suite, right? Because if we look at, even if we take white men and men of color together, that's about, I think I have 53% of entry level. But by the time you get to C-suite, they're almost 80%. Completely different if we look at women. White women and women of color, they're coming in at almost 50%, almost the same percentage as the men. But by the time you fast forward to the C-suite, they're just 20% of the C-suite. So there's an issue with that about am I in this space? Like, am I going to be able to make partner or to get to the C-suite, right? And so this kind of thing is a concern. I often tell people I believe that a lot of this trajectory is as a result of grooming and mentoring, right? Who you take under your wing, how you advance and help people. And so what we see is that the people who are in control, people who are in charge, they tend to, and this is natural, they tend to have an affinity for people who look like them. So those are the people they take under their wings and develop, right? And so then we end up with this kind of disparity, if you will, right? And so there's a message that's sent to people about if I belong, where's my place when we have this kind of pipeline. I think the next slide will also talk about why diversity matters, right? Like, there's a lot of data out there about why should we do this? Is it just because it's the right thing to do? I think it's the right thing to do, but that's not enough, right? Right? So we need a little more, right? But we've got a lot of data now, right? And our data is showing us that if in more diverse environments have created happier people are more productive. Happier people stay at the firm or at the corporation. So your attrition is not as high. It costs a lot of money if you're constantly hiring and trying to retrain and all of that, right? So employers lose a lot if they're constantly losing employees, right? And so there's that. But the other thing, the data has really been clear that more diverse teams are more thoughtful, they're more creative, they're more innovative, they produce more. Huge study out of California that showed how this happens with jury deliberations. The more diverse the jury, the longer they deliberate, the more facts and scenarios they come up with, the more critical thinking that's involved, right? And so we have these different spaces. Even a study just came out not too long ago that showed even if you have women on your boards, you're more likely to be productive, right? And so they're at every level, right? Whether you're talking about jury, whether you're talking about the workforce, whether you're talking about boards of directors, what we're seeing really, I think, is the data would say if you are constantly surrounded by people like you, you're not pushed as much. You know, we're all sort of, I know what you think already, right? Like so that we're not pushing each other. But if you're, just so for example, if you're a Democrat, let's even go political just for a second. If you're a Democrat and you know you're going to present to a Republican, you're gonna work harder, right, than if it's another Democrat, right? And so there's this way that diversity pushes you. And it may be uncomfortable, but at the end, it produces a better result.
That's really, I mean, that makes a lot of sense. I think all employers are looking for, you know, better products, better results. So you guys, so far we've talked about what it is, why it matters. I hope everyone's convinced it does matter. I think it's pretty good. There's some pretty good reasons there. So in the next section, we want to talk about addressing it. We have, Sunny talked a little bit about addressing it. We'll go, you know, we'll just keep going. But we want to talk about some things you can do because, you know, many employers want to address it. You all are busy people trying to do the work that you're trying to do. So I want to turn to you, Sunny. Well, actually, before I turn to Sunny, pop quiz. So we have Professor Norwood here, and we have a chalkboard. I hope you're feeling like you're back in school a little bit. Mike sometimes confuses Casey and Sam for each other. As a result, he often calls the men by the wrong name. Casey and Sam are both Chinese. Mike is not. Is Mike displaying an unconscious bias? So I'm going to give you the answer. I hope you guys know. The answer is yes. It's unconscious. It's implicit. This is certainly something we all run into, and in fact, we all do. This is something I'm sure you see in your company. Employees do things like this. You are likely not going to fire someone for getting the names wrong. But this is a great example of implicit bias and something that you don't want to overlook, let go unchecked for all of these reasons we've been talking about. So
I want to say one thing about that too. So they might be identical twins, right? Like, so there's that.
True. It's not specific. You're right. That's totally true.
So we need more information.
We do need more information. And in that case, I feel like it's
so then now he gets a pass, right?
Yeah.
But the other thing that's really important though is that if you are different, psychology says your mind automatically will categorize people so that it's not, so again, I want to sort of throw this idea out here that it's not that you're this horrible person, right, who doesn't care. Like you are defaulted to automatically lump people who have similar characteristics together. And so that's why it requires more effort on your part and slowness to make sure you get it right.
Yeah. That makes a lot of sense. So moving into addressing it in your workplaces, the examples we talked about before, Sunny, were more along the lines of you get a complaint, what are you going to do about it, right? Is it discrimination? Maybe not. How are you going to handle it? But I think a lot of employers hope they can address bias before they get a complaint. So can you talk about, from your perspective, where you see it coming up, how you see employers, you know, trying to take a proactive approach, and first a little bit about where you see it in employment?
So I think it's on the slide for the audience. Where I think we're used to hearing about it is certainly in recruiting, the recruiting practices, hiring, making sure that you have a diverse pool of candidates, things like that. Discipline, terminations. We talked a little about promotions, and I think that's where a lot of time is spent today. Where I'm seeing more come up is in training. So, for example, this type of training and having different people who look different doing training or looking at the examples. We actually worked on that last example a little bit to make sure that it was, culturally sensitive. So even just looking at the examples you're giving in training, policies, policies sort of sit there for long periods of time, and what was appropriate for a policy 10 years ago, 5 years ago, is not going to continue to forever be appropriate. Investigations, a lot of times investigations are just handled just discreetly. This investigation, we're done, this was the outcome. Instead of pooling the investigations at different periods of time, just to make sure, do we have some sort of issue globally? It might be different people, certainly, but is it the same thing coming up, or in the same group, or in the same region of the country? So trying to look for something broader. Employee communication. That's one that I have seen a lot more over the last year. Just how you're communicating with your employees, whether it's about the news, whether it's about a new policy, whether it's about, just something going on in your company, the words that you use. Often, people who are drafting these communications look alike, or they think alike. Or they might have what they think is visual diversity, maybe people of different races, but don't have different generations. And I have really found that generational, it's very different. How I perceive a communication and how one of my colleagues who's in their 20s perceive a communication are very different. And I am constantly learning that. And I reach out to, individuals, hey, what's going on? Or what do you think about this? Or how did you perceive this? Those people who I'm comfortable asking, and they've said so. And I'm surprised again and again how I did not perceive something one way and someone of a different generation does. Compensation, we're hearing a lot about that. The Equal Pay Act, the scrutiny that the EEOC is giving on compensation, I think it's just going to be turned up. We're seeing more and more states and cities have laws around equal pay. And so if employers haven't or aren't thinking about auditing their compensation, they really should consider it. So anyway, that's where you see it. Just a few places.
And then on the slide, obviously it also says, I think in our examples so far, you've heard a lot on race and gender specifically, where we see it a lot, but it really can cross all types of categories. So those are all listed there. You don't want to miss areas where bias can be, in your workplace. And so moving into the next topic, what I want to do here is, because I wanted to ask about hair discrimination, which we have up here now. Many of you have heard about this or run into this. Hair discrimination, I think a lot of employers have probably heard of recently passed or proposed Crown Acts, and it crosses all aspects of employment. All the areas that you talked about, Sunny, it could potentially come into play. And Professor Norwood, you know a lot about this topic. So yeah, a little bit, yeah.
A little bit.
So I want to get your perspective and your thoughts on it, and we'll just move right. I think we wanted to jump to a different slide too first. So let me, this is one funny too.
Well, can I bring up one other example? This happened a couple weeks ago, and I was really surprised by grooming policies. That's exactly what I was going to address. So a client called, and they have a clean shaven policy, and it's for officers, and there's a real reason for it, making sure they know who the person is. And they don't really make exceptions necessarily. Well, an African-American man came forward and said, hey, being clean shaven actually causes an issue. I did my research because I wasn't familiar, with this issue. And it can create keloid scarring if, an African-American man who has this issue continues to shave. And ultimately, we worked together, and this individual was given the opportunity to have a full beard, which was what was recommended, but very, very short. So everybody, you could still recognize him. But that was the first time in, 20 plus years that had come up. I think in the past, someone wouldn't have even come forward to ask for that accommodation, even though it was actually a very painful daily experience for him. So it's great that he felt comfortable coming forward, and the employer came and we talked it through and figured out the best way to go. So different kind of hair, but
yeah, but that's a good example too. And I
Yeah.
think just because some employers might be thinking too, oh, that's like an ADA accommodation, but I think what you're saying is it's something very common and specific to African American men.
That's right.
And that's where it comes into this issue.
Okay.
Yeah.
So this is another kind of hair issue, and this really doesn't involve facial hair, but hair on your head. And we have employers, throughout the country, right, that have grooming policies, and those grooming policies would say something like. Let me think of an example. Well, this one is a good example.
You don't even have to think of one.
Yeah. All personnel are expected to be dressed and groomed in a manner that projects a professional and business-like image while adhering to company policies. Hairstyles should reflect a business professional image. No excessive hairstyles or unusual colors are accepted. And so this is a typical policy that employers have, and they vary, right? But you get the gist of it. The gist is typically that your hair must be kept clean, neat, and professional. No excessive styles, that kind of thing. So the problem that we have is that how do we define professional? How do we define excessive? And so one of the things that we've seen is that professional has meant not braids, not afros, not dreadlocks, not twists, right? Those are hairstyles that are very common for people of African descent. For many people of African descent, the hair grows out of the scalp extremely tightly curled. So if you do nothing, I'm an example of this now. This is how my hair grows. And if I don't cut it, I will have an Angela Davis afro. I'm dating myself. Hopefully, if you don't know Angela Davis, please look her up. But she, in the 60s, right, had a big fro. That's how the hair grows out of the scalp. It grows out, not down. So then the question is, so what am I going to do with that, right? I could keep the afro neat and clean. I could braid the hair, I could twist it, I could do other things, or which is the default in our country, I could straighten it, right? And straightening the hair could typically involve a hot comb, or it could involve a chemical, right? And so that's a change in order to accommodate a grooming policy. And the question that I always ask is, why is straighter better? Why is that the default, right? If you can have neat, clean hair, right, why does it have to also be straight, right? And so one of the things that we've seen in the Eeoc case is a good example of this. This is a woman, the plaintiff was a woman who was going to be in a call center in a warehouse somewhere. She had beautiful hair, according to the woman who interviewed her. But she said, well, but they're dreadlocks and they might get messy. So we have a dreadlock policy. You'll have to get rid of the hair, the hairstyle. The woman refused and the offer was revoked. It went up to all the way till 11th Circuit, and 11th Circuit said this is a hairstyle, this is a choice. So it's not discrimination based on race, and so the plaintiff lost the case. But that was wrong in my view, right? In my view, that if I have to change my hair, then that's no different from asking me to bleach my skin. Right? It's the same. It is an immutable characteristic, right? That would need to be changed to accommodate the employer's requirement. So this woman here, Brittany Wood, she was fired when she started at the company. You'll see the image on the left where her hair was straight. And then she decided to give her hair a break. She was having some breakage, right? And decided that she didn't want to put the chemical in anymore. So then you see the image on the right, which I think is neat and clean, but she was fired because it was considered unprofessional.
So since we're on this slide, I have a question that I think some people might be wondering about as employers. Can they, isn't it true? I mean, employers, it seems like, should be able to say, we want you to have a professional hairstyle. And I think what you're saying is, we need to remove some of the subjectivity out of what it is to be professional. So in this example, she has natural hair on the right slide. So in that case, is it your understanding they consider that to be unprofessional?
Yeah, she was fired. She was told to straighten her hair, right? That her hairstyle was unprofessional. She refused to do that, and so she was fired. So this question, though, is important because, we see this, and when we get to the school slide, we will talk about this again. But this issue of how do you define professional, right? How do you define excessive? Why is the hairstyle that we're looking at on the right unprofessional, right? So a lot of what we need to do when we're advising employers, in my view, advising employers on taking another look at their grooming policies is to try to figure out, okay, don't have these words in there that are just ripe for bias, right? Like if you say excessive, well, one man's excessive is right. Like it's, so what does excessive mean, right? What does unprofessional mean? And so we have to define those terms, because otherwise what we know for a fact is that people default to their norm, right? And what they think is right and what they think is professional. So unless we open that up and try to get people to understand, I did a session with the ABA it was about a year ago, I guess, talking about this issue. And I had so many employment lawyers in the audience who were like, wow, I hadn't even thought of this, right? Like the default is, right, me, right? The default is straight, right? The default is something that unless you push a person and say, well, wait a minute, if you require that of others, this is how that's going to look, right? Then people just don't know what they don't know, right?
Yeah.
This issue happens in schools as well. And I really love this first image. If you look at these 6 girls on the top of this slide, all of them technically have the same hairstyle, right? And they're all cute and they're all neat and they're all clean. But the 3 on the left were banned, right? Why? Right? Unprofessional, excessive. No, that's the way the person's hair grows out of their scalp. And so we need to have some conversations that broaden people's understanding of what's natural and what's normal.
And along that line, so the next slide that I pulled up is refers to the Crown Acts that I mentioned. Can you talk a little bit about how that plays into this? So
we do have a movement. It's still in its infancy stages, right? But we have this movement throughout the country where states have begun to pass these Crown Acts. And these laws are designed to help people understand that people, depending on your origin, right, your hair may grow out of your scalp differently, right? And different doesn't mean bad. Different doesn't mean unacceptable. And really, so it's really sort of trying to open up a space for hair discrimination. So far, I think as of today, maybe we have at least 8, maybe 9 states that have passed these Crown Acts. So they will prevent a person from being fired because their hair is in braids, locks, or twists. Now, you still may be fired if it's unclean or if it's not neat and some other issues, or maybe even if it's purple, right? But for the natural way with which it grows out of your scalp, you wouldn't be able to, that would be actionable. And so we have, you know, a little under 10 states that have enacted those laws. There's a proposal in front of, well, I guess the session in Missouri is over now, but a bill was offered in the Missouri legislature. It didn't go anywhere. I'm sure it'll come back again. So we're seeing states slowly beginning to pass these laws. I think the House also passed a Crown Act maybe last year, and so it's been sort of sitting in the Senate for a while. But this is really important because we don't have enough time to talk about it. But it really is people. I have 2 daughters, and neither one of them could use chemicals to straighten their hair. It would take their hair out. So not everybody can get a perm. Maybe you can't afford a perm. There's that, a whole separate conversation. They're not cheap. But even if you can, sometimes the chemical reacts with your body in a way that can cause alopecia. You can lose hair, all kinds of things, right? And so if we're in a space where I can't straighten my hair because of the chemical and natural is not allowed, then what is left for me, right? Do I have to buy a wig, right? And wear a wig? Why is that?
It's very interesting. I think, you know, like you said, in Missouri, maybe statewide it's not passed yet, but this is a great practice for employers to start building into their policies and your practices for hiring, discipline, all kinds of areas to start, you know, looking at why are you applying it this way? Because I think it's going to, you know, start, whether it's here or not now, it will start to, you know, be more normalized. And so you all should be really thinking about whether that's an issue in your workplace. Oops. Oh, well, this was, so sorry, I almost skipped this slide, but we did talk about this slightly. This is the hair, an example. We covered grooming policies, but this is a great example here of a more objective form where it's still going to be up to you how you apply your policy and applying, you know, determining what clean may be. But socially accepted style is something we see in a lot of policies and something you should really veer away from. Because of its subjective nature and a lot of potential for bias.
Right.
So moving past that, now, again, going back to some other areas, Sunny, that you mentioned, we'll talk a little bit more about how people can address bias in these are grouped together because they generally go together. But can you talk a little bit about where you've seen bias and how you're seeing employers address a bias in recruitment, hiring, and promotion?
Sure. So one of the most important things that I think employers are doing and should do is anyone who is responsible for recruiting or hiring or making decisions about promotions should be trained. I think often, oh, you're a lawyer, you know, you can certainly interview and your bias won't come into it, or you won't discriminate, or what have you. Or you're a high-level manager, you know, we don't want to have to train that person. That's the wrong way to approach it, for sure. I've done a lot of training for managers on hiring and recruiting, and the questions that I get make it very clear that it's needed. I mean, it's very much needed, either to empower the manager. It's not always to pull them back or to, you know, whatever. And sometimes it's to get them to ask questions because they're so afraid, especially in California, for California employers, they're so afraid to ask questions. You know, I can't ask that question, or I can't talk about that. But at the same time, having a standardized set of questions, that is really critical. If I ask easy questions of someone and because they look like me and we get along, you know, how am I really going to compare them to that next candidate who I ask a lot more difficult questions because they went to a different school, and is that school as good as, you know, where I went to law school, where Professor Norwood taught? So just to put that out there. The same with panel interviews. That is something that we used to see a lot of. I think we're going to see more of it, so that everybody's getting that same experience. And then when they're comparing their experience, it's like, well, how did you hear that differently? You know, so that's really helpful. Promotions, the same thing. A lot of times it's important that you do panel interviews for promotions, or actually do interviews. If you're reaching out for some people to apply or telling some people to apply, it's really critical that you make sure that you're telling your whole team or everybody who's qualified, not just the person you go to lunch with. Hey, I have this opening coming up. And that's, again, human nature. It's not meant to exclude. So you have more access to the person you go to lunch with, who you have a lot in common with. And that's why, you know, often you're going to lunch. So
those are good examples. And when I was thinking, listening to you, thinking, you know, I've heard a lot of employers tell me, when it comes to either setting up goals or quotas for, you know, which goals are, you know, legally what you should be trying to do rather than quotas. However, even with something like goals, I've heard employers say, you know, I just want to hire the best candidate. None of these things matter to me. I don't care what you look like. I just want the best candidate. But I think, based on what you guys have talked about, and if you want to comment on this, my impression is we're fooling ourselves if we think we're that objective, that we are really just choosing the best candidate without any of these other biases coming into play. So I think the things you talked about, I've also heard of like scrubbing names off of resumes, because there's no, you know, demonstrated bias against names people consider traditionally Black or female.
That's right.
And they're less likely to get callbacks.
Right. And there is software available, and companies are adopting their hiring to it to scrub even clubs, you know, or organizations. That would identify a religion or a gender or a race or disability, for that matter. So,
and lots of applicants do that too, right? Like, you know, lots of people will automatically take away things that they're worried people may sort of say, aha.
Social media, that's another one. We say, it's probably not a good idea for you to go out and look at someone's Facebook page or whatever, because you're going to learn about them. Maybe they did a breast cancer survivor walk. Well, now you know that individual had cancer, and, you know, it was just last year. I mean, do you start thinking, or they see a brand new baby, you know, is she really going to, creeping in. They don't even know that it's there. And communications, going back to that again and how that's perceived. I ran across a communication just a few days ago where someone said, oh, we've hired all these really excellent candidates. And we've also really, we've hired some diverse people too. Instead of saying, which the diverse people had the same qualifications, and this individual who was a diverse individual did not mean it in a way that, you know, the diverse people were less qualified, but it could have been perceived that way. And it was perceived that way. Oh, so this is sort of our affirmative action, you know, individuals, when everybody had the same qualifications.
Interesting. So you mentioned the baby, someone with a baby. So that takes us into this next more specific topic that we wanted to cover is a caretaker bias. And this can often be just another version of bias against women, but it also, not exclusively to women, it's been very pronounced during the pandemic. that the people who are home taking care of others have become bias playing against them in the workforce now. So we just wanted to mention this so that you can be thinking about it in your workplace. Now that we're coming out of the pandemic, what are some ways that you can combat and continue to make sure you aren't overlooking this bias, especially coming out of it? Like, who are some of the caregivers and caretakers who have been left behind or who haven't been appropriately trained or advanced? On this slide, you can see some examples of impact on women, specifically women being most typically caretakers. These show some ways that we're seeing that in the workplace. Do either of you, feel free to chime in if you want to add to that?
Well, one thing that I think employers really need to be aware of is, Carrie just showed some headlines about caretaker bias, which means your employees have read those headlines. They've read those articles, and they will then look for that kind of discrimination. So it's a newer one. I think the pandemic certainly did shine a light on it. So the first thing I would say is making sure that you're looking at this kind of bias at all, because a lot of employers simply aren't looking at it. Some of the things that employers have done is having the paying for tutors for virtually, so that people don't have, women often don't have to take that time away from the workday, allowing different types of hours, doing the remote options, on-site childcare. We have an employer in town here who subsidizes all of their employees' childcare, and it's very close to where they work. And I was talking to a mom, and she was just overjoyed. It saved her a lot of money, for one thing, and it allowed her to feel comfortable going to work because she, had this great childcare option.
Yeah, that's great. So some additional things before we wrap up. A couple other terms that we didn't introduce in the beginning, but I think many people are familiar with, and I wanted to raise them as, to leave you with some of this. But allyship, which many people are familiar with, many employers have programs in place and different strategies for creating allies at work. And then also the term microaffirmations,
which I had not heard of. So again, even getting ready, I was learning.
we were learning about this as well. But in counteracting microaggressions, people have started to talk about microaffirmations. Yeah. And so, Professor Norwood, if you wanted to add to some, like the allyship issue is a big one.
So this slide here, and as we sort of wrap up, we're sort of talking about, okay, so what now, right? Like, how do we deal with this? And really, one of the things that you have to keep in mind, I hope, is that we're looking at two different legs. So one thing is me, like we all are biased. And so sort of thinking about how we can do things better, right? How we can be allies. And this example that you gave about a diverse person who makes that faux pas, right? Like that we're all biased, right? Like we're all subject to that. And so we have to do work on us. Separately from that, we have to do work at the place of employment, right? You have policies that will, just like your thermostat, keep rolling automatically unless you do something different, right? And so we've got a policy, practice, rules issue, and then we also have the we issue, the individual issue. This slide here and the next one will focus on the individual issue. What can you do to become a better ally, right, for people in your workspace? And so this term microaffirmations really speaks to how you can do small things, ask people for their opinions, recognize the achievement of others, smile, friendly, the smile, using
She and I laughed about that a little.
using friendly facial microaggressions. But there's another term that's broader than this, and it's called micro-interventions. Fabulous book just came out. It's on your readers list about micro-interventions. And it's a little bit broader, but it's the same concept. It's about you as an individual recognizing that you have a bias, and once you recognize that, then doing something about it, self-help. Right? Reading, watching some TED Talks, doing some things that will help educate you about your biases, right? After you do that, okay, what about if you're in a meeting, right? And you see that someone's being spoken over or interrupted. You not staying silent, right? Like you supporting that person and say, well, Carrie just said such and such, or Carrie, what do you think? Lean In calls this term lean out. Lean out to involve people, right? Don't just sit back and let things happen, right?
Like, let Carrie, I want to let you finish your thought.
Yeah, and what I know what yours, because the data, I think many people know this, suggests that women and people of color often are, sitting in a meeting and may have something to say or may start to say something, and then someone else may take credit for the idea that was just stated. And so that's a great
There's a lovely illustration of what this term is called he-peating. Have you heard that? Repeating is he-peating. So,
like
mansplaining is.
Sorry, you're getting a panel of women here right now. So that's great. And the last things I want to make sure we leave you guys with. So people have also, there may be some of you out there who have dealt with lawsuits claiming reverse discrimination. We've all probably recall the last administration putting out an order, banning types of anti-bias training. We also have seen some legislative action that tries to sort of like contain and put a stop to some of this bias, attacking bias. So I think, Sunny, if you want to comment on that before we wrap up.
Sure, absolutely. And we completely understand the sensitivity around different workforces, different geographic, and all these changes. But at the end of the day, it's critical. You're so much less likely to have a reverse discrimination lawsuit than you are to have gender discrimination or race discrimination in the traditional sense. And bias training will help you avoid that. And even the executive order that was issued last year that was rescinded wasn't as broad sweeping as people might have imagined it to be. So making sure you're connecting with someone who's familiar with the, whatever's going on in the law, like the legislative actions that we're seeing for curriculum.
And just example. Make sure, that these things should not be stopping you. Call us if they make you worried, but they shouldn't stop you from, moving toward the elimination of bias. And so last, our 3 takeaways that I actually hope you remember everything we said today, but if you don't for some reason, these 3 things I hope you'll take away. First, bias is everywhere. Second, bias is worth confronting in the workplace. And last, combating bias is ongoing and often uncomfortable. Thank you very much. Thank you so much, Professor Norwood, for joining us.
Really appreciate it.
And it was great talking with you both.
Okay.
And I also don't want to forget to mention the suggested books and videos, this awesome list. You cannot read it from the prompt. It's a lot of stuff, but it's awesome. It's Professor Norwood put this together. So please continue to read and improve your cultural competency. And back to you, AJ.
Thank you so much, Carrie. And of course, thanks to Sunny and particularly to Professor Norwood for that wonderful panel presentation. Certainly worthy of all of the affirmations, micro and otherwise. And I will avoid repeating any of the lessons that they gave there, but they were certainly useful and very helpful to me and to all of us. And if for no other reason than it satisfies that elimination of bias credit for many of you who attended. And speaking of which, we've got some housekeeping items as we close up here. And that is, in order to make sure you get credit for attending today, make sure that you go down to the bottom of your screen and look at the CEU icon, which will allow you to report those matters. Again, you'll get a certificate of attendance along with a recording And at the bottom of your screen, you can also access a PDF of the materials. So to the extent that you wanted to take a closer look at the list of suggested reading that you just saw on the screen, that would give you an opportunity to do so. And then finally, be sure to complete that survey before you hang up today. We appreciate all of the thoughtful feedback that we receive, and we spend time with it, and we do our best to incorporate that as we're designing our programs in the future. So thank you again for sharing some of your time with us today, and we look forward to seeing you again soon. And this concludes our program. Thank you.